Okay, pause before we even begin. This judge woke up today and chose maximum authority. No warm-up, no easing in. This opening line basically tells everyone, welcome to my courtroom where nonsense dies instantly. Notice how he jumps straight to consequences, contempt, fines, jail time. This is what judges do when they've dealt with this case for far too long and their patience meter is reading dangerously low. Buckle up, this hearing is heating up fast.
Yeah, if you say one more word like that, I'm going to find you. You understand me? I don't play games like this, man. You want to play with me? I can play tough. You can end up in Bell County for a few days if you don't mind, if you want me to go that route. Understood?
Um, Thank you, Judge. And state is in agreement with the ad litem and the order that he had circulated previously as he described it to the court.
All right, thank you. All right, Mr. Smith and Miss Bonner, since you're pro se litigants, represent yourself and not lawyers, I need both of you to raise your right hands while I put you back under oath. Thank you. All right, do you both solemnly swear or affirm the testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you?
Yes, sir.
Here's something crucial. Both parties are representing themselves, no lawyers. That means the judge has to spell out procedures in slow motion, almost like a teacher explaining rules to kids before recess. Judges don't love doing this, but they must ensure fairness. Every word has to be on record, every oath redone, every question simplified. And trust me, when people are emotional and untrained in law, these hearings can go sideways in seconds.
All right, you're both officially in the oath, and I'll let the state go ahead. I'll let the ad litem go ahead and confirm whether or not you're in agreement with the order, and then the court will make a ruling on whether or not the court will just go ahead and assign the order as represented by the ad litem. So at this time, you may proceed, Mr. Bramall.
Thank you. I don't believe I can share.
Don't even share it. If you send it to everybody, they got a copy. Just confirm they got their copies and whether or not they're in agreement with it. All right, that's all you need to do, sir. Thank you.
Okay, and I did have two questions for the court about issues related to the order myself. But the order that was circulated, I'll start with Miss Kanaba. Can you hear me?
Yes.
Am I saying her name right? Kanaba or Kanaba?
It doesn't matter. Kanaba is the Spanish and Canaba is the English way.
The inappropriate version of the name, okay?
Okay.
But anglicized, okay.
I sent out a copy of this order to both of y'all by email. Did you get a chance to? Well, first off, did you receive the email?
Yes.
Okay, and the order as I've sent it out is 19 pages. Did you have a chance to review that?
Yes.
And it addresses all of the rulings from the court that were made at the final hearing on October the 6th. Is that your understanding?
Yes.
Do you have any questions about any of the contents of the order? Or any disagreements with the order?
This moment seems small, but it's huge legally. She says she has no disagreements with the 19-page order. Her voice is unsure, but in court, hesitation still counts as agreement. Judges rely on clarity. If you don't raise a specific objection, the train doesn't stop. Even if you regret it later, the record shows you agreed, and the record is everything. This is why having an attorney often saves people from moments like this.
No, not that I can think of now.
Okay, so regarding the entry of this order, you're not opposed to it being entered as the final order, is that correct?
I'm not really understanding.
Do you have any legal opposition to this order as it has been presented and drafted?
As in him getting possession to Harper, or?
Okay, he's going to his question. I know you're not a lawyer, and that was a lawyer question. But I have a copy of the final order that's been proposed to be entered at this time. Is there a legal reason why the court should not sign off on this order as is, ma'am? That item says he might have something to clarify here in a moment. But as it stands right now, do you have a legal objection to the court signing the order?
Just her being neglected, but other than that, nothing else.
Okay, ma'am, that really not, there's nothing to order about neglect in any of my court orders, so I'm not sure what you're talking about.
I wouldn't like the state to sign it if we don't get this through to y'all, but my answer is no.
All right, thank you. All right, Mr. Brimall, you may proceed.
And Judge, I just want to make sure that you have the order there were two versions that were sent out. You have the order that on page 5.
And here it happens, she brings up neglect. From an emotional standpoint, completely understandable. From a legal standpoint, absolutely not allowed at this stage. This is an order entry hearing, not a trial. You can't drop new claims or evidence right now. The judge knows that opening this door would turn a quick administrative hearing into a 4-hour meltdown, so he shuts it instantly. Watch his tone, it shifts from patient to laser sharp in milliseconds.
It has the possession and access with the definition in parentheses on the second line. Is that right?
All right. Possession and access.
And it should define the Saturdays in parentheses in the second line. Is that the version you have?
Yes, it is.
Okay, good. Okay. All right. So we're looking at the same one. Okay. I will call Mr. Smith. Then, Mr. Smith, can you hear me?
Yes, sir.
All right. And I sent this order to you as well. Did you receive the email?
Yes, sir.
And did you have a chance to review it and take a look at it?
Yes, sir.
Are you are you in
Is it
agreement
simply-
or opposed to the court entering this order?
I'm opposed to it for the visitation side.
Okay. Please elaborate your objection.
All right,
The
all right, here's the deal. All right,
sex-
stop. Here's the deal, guys. Sir, you can object to anything that was not a court ruling. You cannot object to the ruling of the court as far as visitation is concerned. If you got something that you said is not correct, or there's something I didn't rule on, that's fine. But if you're just saying you're not in agreement with it, sir, that's not what that portion was about. Thank you.
I'm
Okay, so
confused. I thought I was asked if I was
I'll
in
ask him.
disagreement on something.
I'll ask a follow up. So, Mr. Smith, you're opposed to the section on page 5, the possession and access. Is that that's what you're opposed
Yes,
to?
sir. Yes, sir.
Okay. Are you opposed to it because you don't agree with the ruling of the court, or are you opposed to it because you believe it does not reflect the accurate ruling of the court?
I'm opposed. I just opposed to the ruling, I guess.
Okay. But given what the ruling of the court was, do you believe the language as contained in these paragraphs reflects that ruling?
Yes.
Okay. All right. So you're opposed to the substance, not the form. Do you understand what I'm saying?
Yes, sir.
Okay. All right. Okay. Anything else in the order that you're opposed to or find objection to?
No, sir.
Okay. Now I have a follow-up question for you specifically regarding court costs on page 14 at the bottom. You were ordered by this court to pay court costs in two specific amounts. Number one is the normal court costs, and the second one is drug testing reimbursement court costs. Do you understand that?
Yes, sir.
Okay. And you were supposed to have paid those or had the payment ready by last week on the 30th. Do you have the payment for court costs with you?
Here's courtroom reality. Forgetting money orders is a huge deal. Courts rely heavily on deadlines, especially for costs and fines. But instead of throwing the hammer, the judge takes a practical route. Since the guy lives far away, they'll mail the payment through the ad litem as a middleman. This is actually the system bending to avoid problems, because trust me, lost money orders can turn into legal chaos. You can feel the judge trying to keep this train on the tracks.
I have both the money orders at home. I didn't bring to work. I forgot. I wake up really early.
Okay, so you're telling the court that you have two money orders, one for $443 and one for $299 ready to send to the court?
Yes, I have the other one as $300 for the change, but yes, sir.
Okay, all right.
Real quick, sir. Real quick. Where do you live, sir?
I live in Cleveland, Texas.
Okay, then. All right, then. I normally like people when they're dealing with money orders, if they live locally, bring it in and then get your receipt directly from the clerk. That way, you know there's no way that can go wrong. Okay. But since you're out of town, you can go ahead and mail it in. But I'll let this. And if you have any questions about that, you can get with the ad litem later. You may proceed.
Yes, sir.
Yes, Judge. This is a question I had for the court as well. About this particular section. You had, Mr. Smith logged out of his final hearing and was not present for the rendition of the final ruling. And this court instructed me to talk to him about the ruling specifically about the court cost provisions and the necessity of them being paid and the importance of them being paid and so on. Did the court want me to be the middleman on?
Let's do it that way. Yeah. Again,
Okay.
that way, I hate the United. I'm sorry. I do not hate the United States mail. I just don't like sending things, money orders and things like that through the mail because the clerk's office may get it wrong. Some of the mailer may get it wrong. There's too many steps in there. So, sir, I'll have you forward those directly to Mr. Bremhall. He will personally take them next time he's at the courthouse down and deposit them into the registry of the court and send you a receipt for such. All right.
Yes,
Okay.
sir.
Okay,
Right,
that's
yeah.
what that was my question because I
Oh,
know
yeah.
this court wanted to make sure that those got paid. So
Yes, sir.
I can send a prepaid stamped envelope to Mr. Smith, and then he can return the money orders to me in said envelope, and within a day of receiving such, and then I will take the money orders and make sure the court costs are paid for this case using those money orders.
All right, good enough. Thank you. Next question, then, sir. You may proceed with your next question, Mr. Bremhall.
Okay. My final, so Mr. Smith was regarding anything else. So in this order, it has your address listed on West Country Road in Cleburne. Is that correct?
Yes, sir.
Okay, it has not changed. And
No,
if
sir.
if I send you a self-addressed stamped envelope to that, you will get it. Is that correct?
Yes, sir.
Okay, is that a PO box like attached to your house, or is that like a mailbox in front of your house, or is it a PO box?
It's like a PO box, but it's not a PO box. It's a community mailbox up there by the office.
Yeah.
Is it
Okay.
okay? Is it locked? I guess what I'm asking.
Yes, sir. Yes, sir. It's locked.
Okay, okay. I just want to make sure no one will tamper with the mail. Okay, all right. Okay. Then my only remaining question would be the court hadn't ordered me released from the case. I'm assuming the court wants me released 30 days from today's date or 30 days
30
from
days from me signing the order. 31 days after I sign the order, you're officially released when it becomes final.
Okay, and so I will submit a separate order for that. But yes, okay.
All right,
So Mr. Smith, did you have any other questions about the order that will be submitted?
No, sir. Not about the order, but whenever there's a second at the end, I do have a question.
All right, there's a second at the end, sir. What's your question?
I'm looking into council. I'm getting a retainer fee put together. Doing that, I can talk to them about bringing all this back because of the way all this was handled.
Sir, you can talk to any lawyer you wish, and you and your lawyer can strategize anything you think is appropriate, sir. All right, yeah.
Yes, sir.
No two
Thank you.
lawyers are going to do everything exactly the same, sir. So that's why I got to be real general because it just depends on who you hire and what y'all figure out what y'all want to try to do. All right.
Okay,
Yes,
Judge.
sir.
Judge, my final question would be for the court. Does the court want to sign the order that it has in front of it, or would you prefer that it get e-filed so you can sign via e-filing?
I'm gonna go ahead and sign the one I've got here, and hopefully they won't throw a fit at the clerk's office about it.
Okay.
No, you can get e-filed, Mr. Bremhall.
Okay, they gonna throw it. Linda's
Okay.
polite way of telling me, yeah, the clerk's gonna throw a fit.
Okay, I will e-file the order that I circulated and that you have in front of you. I will e-file it as soon as we log off of court today. And did you want it to be circulated for signatures or just submitted?
Just for me.
Okay, I will submit it with no signatures just for you.
Okay, and I'll note that we had a hearing. I tell you what, do a separate order attaching, the court granted the motion for entry of order. Okay.
Okay. All right. I'll submit those separate. I'll submit each order separately so that there's a fresh order, final order in the file.
All right. Good enough. Thank you. All right, everybody. Thank y'all all very much. Everybody have a good New Year and a Merry Christmas, and take care, folks. And I'm gonna may the parties be excused at this point. Then, Mr. Bremhall and Mr. Gwynn.
I believe so, Mr. Smith. I'll be in touch with you by physical mail and by email.
I have a question.
Yes, ma'am. What's your question?
Are we getting released from court? Like it's final and things are being signed?
Yes, ma'am. This is a final order. That's what that means. And what that means, I'm going to sign an order as a final order of this court, and under Texas law, you lose the right to appeal that 30 days after I sign it. So it's got 30. That's 30 days. It's still out there. So for y'all to file anything that y'all think is appropriate.
May I say something if we're going to be
No, ma'am.
released off of court?
Okay. Now, what do you want? If it's what's it about? What is the subject of what you want to say, ma'am?
My child being neglected on November
Okay, ma'am.
15th.
Stop. We're not taking any more testimony. I've made my
How you
ruling,
doing?
and we're not. And that's it, ma'am. No, ma'am.
She
you're
was
not saying that.
neglected. She was not paid.
Ma'am.
Oh, wow. Okay.
Here's the deal, ma'am. This is my court. You are not. We're not. We've passed all that. All testimony has closed. All right. This was an order. This was a hearing to enter order, and I grant the entry of the order, ma'am.
This is the emotional explosion the whole hearing has been building toward. She tries again desperately to raise neglect claims, but legally testimony is closed. Once closed, it's like locking a vault. She keeps pushing and the judge goes full storm mode. Threatening contempt isn't casual, that's a judge saying, "I will put you in jail if you keep disrespecting this process." The emotional weight is real, but the legal wall is unbreakable. This is the courtroom at its rawest, emotion versus procedure.
All right. So it's okay for my child to be neglected. Thank you.
Ma'am, if you say one more word like that, I'm going to find you. You understand me? I don't play games like this, man. You want to play with me? I can play tough. You can end up in Bell County for a few days if you don't mind. If you want me to go that route, understood? Do you understand me, ma'am?
Yes, sir.
All right. This was present the order, Mr. Brimhall, and we're off the record. Thank you.
Thank you.
Are we free to go, Your Honor?
Yeah.
You're free to go, and I'll sign the order as soon as Mr. Brimhall sends it over. Thank you.
Yes, sir. Thank you.
Okay. I'll make sure both of you will get a copy by e-filing and email as well. Okay. Oh, he's gone. Here, do you let? All right.